The HOA didn't know the ground they were drilling into carried federal protections, criminal penalties, and a paper trail with my family's name on it. They thought they were installing community water. What they actually did was trigger an investigation that erased their board, bankrupted their HOA, and handed me total legal control without me raising my voice once. I didn't buy the land to start a war with an HOA. I inherited it. That distinction mattered more than the HOA Karen ever understood. The property had been in my family for generations, rolling acreage just outside a neatly boxed HOA development that liked to pretend it was self-governing royalty. They had gates, rules, fines, and an HOA board that loved flexing power over residents who didn't know where the real lines were drawn. What they didn't advertise was that their entire community water project depended on land they did not own, my land. The first letter from the HOA arrived 6 weeks after probate cleared. It wasn't a request. It was a notice. HOA letterhead, HOA legal language, HOA authority dripping from every sentence. Community water access survey scheduled. Cooperation required. I laughed. Then I reread it slowly. The HOA Karen board president, of course, had signed it personally. She used words like eminent necessity and community infrastructure, clearly hoping those phrases sounded official enough to scare me into silence. She didn't ask for an easement. She didn't request permission. She simply assumed compliance. That was her first mistake. I replied calmly, professionally, and in writing. I asked for permits. I asked for surveys. I asked for proof of water rights, drilling authorization, and land access approval. I even CC'd the county water office to keep everything transparent. The HOA board responded the next morning. They ignored every question. Instead, they escalated. Within a week, orange flags appeared along my fence line. Spray paint marked the ground. A subcontractor truck rolled in with drilling equipment. No permits posted. No county signage. No notice beyond a flimsy HOA memo taped to a mailbox post. That's when I realized this wasn't ignorance. This was entitlement. The HOA Karen believed that because her HOA had existed for years, because she collected dues and issued fines, because she controlled people who didn't push back, she could do whatever she wanted, including drilling on private land she did not own. I documented everything: photos, dates, license plates, conversations recorded legally. I sent one final certified letter stating clearly, no access is authorized, no drilling permitted. Cease immediately. The drilling began the next morning. The sound was unmistakable. Heavy machinery biting into earth that had been surveyed, mapped, and regulated long before the HOA ever poured its first sidewalk. I drove out to the site and stood there calmly while the drill churned. The HOA Karen arrived 10 minutes later, clipboard in hand, smug confidence on her face. She told me, in front of workers, that the HOA had community water rights and that my land was part of the shared watershed. She said resisting would result in fines, legal action, and possibly law enforcement involvement. I asked one question: can you show me the permit? She snapped back, we don't need your permission. That was her second mistake. What the HOA Karen didn't know, what she didn't bother to verify, was that the land beneath her drilling operation wasn't just private property. It sat above a protected underground pipeline corridor, marked, registered, federally regulated. I knew because my grandfather had signed the original easement agreement decades earlier. The documentation was in the family records. The pipeline wasn't visible, but its boundaries were clear to anyone who did their homework. The HOA did not. The drill hit resistance just after noon. At first, the workers thought it was bedrock. The machine strained. Pressure built. I stepped back. Then it happened. A violent release of force. A thunderous crack followed by a blast of dirt, water, and ruptured pressure lines. Alarms screamed. Workers scattered. The drill rig jerked sideways as water surged from the ground like a geyser. Emergency shutoff systems kicked in across the grid. Within minutes, sirens echoed across the valley. The HOA Karen stood frozen. The pipeline had been breached. Federal response vehicles arrived faster than the HOA board could invent excuses. The site was locked down. Workers were interviewed separately. Documentation was demanded immediately. The HOA Karen tried to claim it was my project. That was her third and final mistake. I handed investigators my paper trail. Every letter, every warning, every ignored request, every unauthorized action taken by the HOA board under her direction. Her signature was everywhere. By sunset, the HOA's community water project was officially classified as illegal drilling. By midnight, the HOA board was instructed to cease all operations and prepare for federal review. The HOA Karen stopped making eye contact, and that was just the beginning. By the next morning, the HOA board was already rewriting history. Emails started circulating before sunrise. Panicked, poorly worded messages marked urgent and confidential. The HOA Karen called an emergency board meeting, close to residents, held in a clubhouse that suddenly felt more like a bunker than a community center. They didn't invite me. They didn't need to. I already had everything I needed. Federal inspectors returned with county officials and pipeline authority representatives. Red tape appeared overnight, literal tape cordoning off the drilling site. The ground was classified as a hazardous zone. The phrase, unauthorized excavation near protected infrastructure, appeared repeatedly in their reports. That phrase mattered. It meant fines. It meant liability. It meant criminal negligence if intent could be proven, and intent was everywhere. The HOA Karen's first move was denial. She told residents the incident was a minor misunderstanding. She blamed the contractor. Then she blamed outdated maps. Finally, she tried blaming me, claiming I had failed to disclose underground risks. That argument died instantly. Disclosure only applies when someone has the legal right to be there. They didn't. The HOA had no easement, no water rights, no drilling permits, and no authorization to touch my land. Every legal expert the investigators spoke to said the same thing. The HOA board had acted outside its authority. Residents started asking questions. Why was the HOA drilling on land it didn't own? Why were federal agencies involved? Why was their water pressure suddenly inconsistent? The HOA Karen responded by sending violation notices to anyone who spoke too loudly. That was her fourth mistake. The federal investigators requested HOA records, meeting minutes, emails, vendor contracts, financial approvals. Every board decision connected to the community water project was pulled apart line by line. The paper trail was devastating. The drilling plan had been approved without legal review. The HOA Karen had overridden a board member who questioned land ownership. She had signed off on payments to the contractor despite missing permits. She had sent emails instructing them to move forward quietly before outside parties complicate things. Outside parties. That was me. One by one, board members were interviewed. One by one, they distanced themselves from her. I raised concerns. I assumed permits were obtained. She told us legal had cleared it. No one wanted to go down with her. The HOA's insurance provider suspended coverage pending investigation. The contractor terminated their relationship immediately. Vendors stopped responding. Attorneys stopped returning calls. Then the lawsuits began. The pipeline authority filed first. Federal fines for infrastructure damage don't start small. Then the county followed. Then residents furious about water disruptions and HOA mismanagement filed a class action suit against the HOA board for negligence. The HOA Karen called me directly for the first time. She wasn't shouting anymore. She asked if we could resolve things amicably. She suggested shared responsibility. She hinted that if I accepted partial blame, the HOA might survive. I declined politely. I reminded her that I had warned her in writing not to drill, that I had requested permits, that she had proceeded anyway. I told her I would cooperate fully with investigators, exactly as I had from the start. That night, the HOA board voted to remove her as president. It didn't save them. Federal authorities expanded the investigation. What began as illegal drilling turned into financial audits, permit fraud inquiries, and governance violations. The HOA's authority itself was questioned. Residents stopped paying dues. The gates stayed open. The illusion of control collapsed, and quietly, methodically, the groundwork was laid for what came next. By the time the case reached court, the HOA no longer resembled an authority. It was a shell, the clubhouse set mostly empty, board seats were vacant, notices went unanswered. The same HOA that once threatened fines over lawn height now struggled to afford its own legal counsel. Residents had stopped believing in it, and worse, they had stopped fearing it. The courtroom was quiet when proceedings began. No drama, no shouting, just facts. Federal investigators testified first. They laid out timelines, permits, or rather, the complete absence of them, and a technical breakdown of the pipeline breach. The judge listened carefully as expert. Witnesses explained how the drilling location was clearly marked in federal registries and county infrastructure maps the HOA never checked. Then came the emails, printed, time-stamped, projected onto screens for everyone to see. Messages from the HOA Karen instructing contractors to proceed before ownership questions slow things down. Messages dismissing concerns from other board members. Messages referencing handling the homeowner later. That phrase came up more than once. The HOA's attorney attempted to argue shared liability. That argument collapsed under its own weight. The judge stopped him mid-sentence and asked a single question. Did the HOA have legal access to the land? The answer was no. That ended it. The court ruled that the HOA had engaged in unauthorized drilling, negligence, and willful disregard for property rights and water regulations. Federal fines were upheld in full. The pipeline authority's damages were awarded without reduction. Then came the ruling that mattered most. The HOA was found to have operated beyond its legal authority for years, collecting dues, enforcing rules, and managing infrastructure without valid land rights or compliance oversight. Its charter was revoked. The HOA was dissolved. Board members were held personally liable for portions of the damages. Several reached private settlements. One faced criminal charges related to permit fraud. The HOA Karen didn't look at me when the verdict was read. I didn't need her to. Control reverted where it always should have been. My land, my water rights, my access. The community was given a choice: negotiate lawful easements under new management or accept reality. They chose reality. I didn't raise my voice once. I didn't threaten. I didn't rush. I let the law do exactly what it was designed to do. The drilling site was restored under federal supervision. New boundaries were marked clearly. Permanent signage installed. No ambiguity remained. The road the HOA once controlled, access renegotiated legally, transparently, and without entitlement. The neighborhood survived. The HOA did not, and that was the difference between authority and arrogance.